5 seconds to go. Start. Court, however, reversed this decision, noting that the vehicle was used as a taxi and hence it was a commercial vehicle. It held that a separate license is necessary for driving a commercial vehicle. The Supreme Court, however, restored the decision of MACT, stating that the driver with a LMV license was legally competent to drive the Max cab used as a taxi. The court additionally considered sections 146, 147, and 149 of the MV Act and noted that under certain circumstances, insurers could limit their liability, but they were still bound to pay compensation to third parties. The right of third parties to compensation was protected by law, and the insurer could later recover the amount from the insured if any policy violation occurred. The Supreme Court categorically held that since the driver had a valid LMV license and the Mahindra Maxi cab was classified as an LMV, the insurance company was liable to pay the compensation. The following was the relevant discussion for what appears to be the correct conclusion in S. Eyappan Supra. In the instant case, admittedly, the driver was holding a valid driving license to drive light motor vehicle. There is no dispute that the motor vehicle in question by which accident took place was Mahindra Maxi cab. Merely because the driver did not get any endorsement in the driving license to drive Mahindra Maxi cab, which is a light motor vehicle, the High Court has committed grave error of law in holding that the insurer is not liable to pay compensation because the driver was not holding the license to drive the commercial vehicle. The impugned judgment, Civil Miscellaneous Appeal Number 1016 of 2002, order dated 31st October 2008, is therefore liable to be set aside. Similarly, in Kulwant Singh versus Oriental Insurance Company Limited, the question for consideration was whether the insurance company had recovery rights for breach of conditions of insurance policy when the driver possesses a valid driving license for driving light vehicle but fails to obtain endorsement for driving goods vehicle. In that case, the legal representatives of the deceased had filed a claim before the MACT following a road accident death on 8th October 2005. The deceased was driving a Tempo which was hit by a Tata 407 Tempo. The tribunal held that the claimants were entitled to compensation. The High Court, however, held that there was a breach of policy conditions and the insurance company was entitled to recover the compensation amount from the owner of the vehicle. The two-judge bench of the Supreme Court opined that the issue stands covered by the judgment in S. Eyappan Supra. It therefore held that the insurance company could not avoid liability merely because the driver did not have an endorsement to drive a commercial vehicle. In view of the reasons assigned by us and as rightly noted in Mukund Devgan 2017, the decisions in S. Eyappan Supra and Kulwant Singh Supra were decided correctly. However, as regards the reliance on Enappa Irappa Nisaria Supra post amendment in section 10 also, the law continues to be the same for vehicles falling within the LMV category. Therefore, the judgments where the court has held that a separate endorsement for a transport vehicle may not be necessary, that is, in Ashok Gangadhar Maratha Supra, Nagaseti Supra, S. Eyappan Supra, and Kulwant Singh Supra, are found to align with our reasoning and interpretation and they are therefore upheld. In consequence, the three judgments which concluded otherwise, that is Prabhu Lal Supra, Roshan Ben Rahe Mansa Fakir Supra, and Angad Kol Supra, are overruled based on the reasoning provided by us in this judgment. The decision in Anappa Irappa Nisaria Supra is partially overruled to the extent that the position, even post amendment, would remain the same. Shifting gears, we may recall that the decision in Mukund Devgan 2017 was doubted for not noticing certain provisions of the MV Act and MV rules. These include inter alia section 41714, the second proviso to section 15, and section 180 and 181 of the MV Act. It was therefore argued before this court that the said decision is per incurium. To begin with, it is useful to refer to some decisions that have expounded on the principle of per incurium. The term per incurium is a Latin term which means by inadvertence or lack of care. English courts have developed this principle in relaxation of the rule of stare decisis. In Halsbury's Laws of England, the concept of per incurium was explained as under. A decision is given per incurium when the court has acted in ignorance of a previous decision of its own or of a court of coordinate jurisdiction which covered the case before it, in which case it must decide which case to follow, or when it has acted in ignorance of a House of Lords decision, in which case it must follow that decision, or when the decision is given in ignorance of the terms of a statute or rule having statutory force. A decision should not be treated as given per incurium, however, simply because of a deficiency of parties or because the court had not the benefit of the best argument, and as a general rule, the only cases in which decisions should be held to be given per incurium are those given in ignorance of some inconsistent statute or binding authority. Even if a decision of the Court of Appeal has misinterpreted a previous decision of the House of Lords, the Court of Appeal must follow its previous decision and leave the House of Lords to rectify the mistake. Lord Evershed in Moral versus Wakeling, for short Morale, explained the concept as under. As a general rule, the only cases in which decisions should be held to have been given per incurium are those of decisions given in ignorance or forgetfulness of some inconsistent statutory provision or of some authority binding on the court concerned, so that in such cases some part of the decision or some step in the reasoning on which it is based is found on that account to be demonstrably wrong. A few months later, after the decision in Moral Supra, the Constitution Bench of this court in Bengal Immunity Company Limited versus State of Bihar adopted the per incurium principle. It held that while Article 141 states that the Supreme Court's decisions are binding on all courts within the territory of India, this does not extend to binding the Supreme Court itself, which remains free to consider its judgments in appropriate cases. In Mamaleshwar Prasad versus Kanhaiya Lal, reflecting on the principle of per incurium, this court, speaking through Krishna Iyer Judge, held thus: certainty of the law, consistency of rulings, and comity of courts, all flowering from the same principle, converge to the conclusion that a decision once rendered must later bind like cases. We do not intend to detract from the rule that in exceptional instances where by obvious inadvertence or oversight a judgment fails to notice a plain statutory provision or obligatory authority running counter to the reasoning and result reached, it may not have the sway of binding precedents. It should be a glaring case, an obtrusive omission. No such situation presents itself here, and we do not embark on the principle of judgment per incurium. Stop.